not had a coup in the matter of Delos Shipholding and others, and Allianz Global Appellants S.A. and others.
Good morning.
Good morning, my lady, my lords. I was dealing with principles of interpretation in relation to exclusion E at the end of yesterday, and what I propose to do is just finish that topic off by reference to the authorities. That's for two reasons. One is I would like to make good the points I've made to you, which is often the reason why I refer to authority, but secondly, just to put them on one side once I've referred to them. So this is probably the most efficient way of dealing with it. The point which I want to get across is, even though there are occasional references to the need to adopt what was described as a broad construction in the context of the English Institute references to customs regulations, one can't run away with that. And moreover, one has to understand why that has been said in the past. And so what I propose to do is take you to three authorities briefly and then move on. The first authority is the Theobolos of Rhodes, which one can see in Authorities Bundle 3, tab 35. Page 1053. And at the end of the page, paragraph 39, there is a discussion in the context of the customs regulations. And I won't read it. What I want to take your lordship, my lady and your lordship to is 39 to 43. But the reason why customs regulations was given what was described as a broad interpretation is because often laws in other jurisdictions dealing with smuggling and contraband weren't dealt with under customs laws as so described. And therefore, to enable if you like, a substantial or purposive interpretation of customs regulations, to embrace what we in England might describe as customs regulations, it's therefore interpreted to include any laws dealing with smuggling and contraband. That's the broad nature of the interpretation which has been referred to, nothing more. But what I want to, and this is made good at paragraph, after referring to the UNITA, Lord Justice Clark at paragraph 41, says, quite apart from the question whether the UNITA gives the expression customs regulations a settled meaning, the construction of the term adopted by the court seems to me to be correct. In ordinary parlance, I would describe customs regulations as including both regulations imposing duties and regulations prohibiting imports altogether. So either restricting imports by the imposition of duties or by prohibiting imports. It seems likely that both might be drafted in the same way. And then in paragraph 42, Lord Justice Clark says, in the circumstances, I agree with the judge that when construed in its context in the light of the principles identified above, the expression detainment by reason of infringement of any customs or trading regulations includes both the above types of regulation. In short, it naturally includes regulations absolutely banning imports, just as it includes regulations imposing import duties. And any other construction would make no commercial sense in the context of institute clauses. Now, just pausing there, in the interpretation of customs regulations, what the Court of Appeal, what Lord Justice Clark was really focusing on was the importation of goods into landed territory. That means when goods arrive in the territorial land of a particular nation, they're either landed goods or they're not. They have to be cleared by customs or they're not. That is what customs regulations are concerned with. And what Lord Justice Clark finishes with in paragraph 43 is this. I would, however, add that it does not follow that all regulations enforced by customs in a particular port would be within the clause, or indeed that regulations not enforced by such customs would be outside the clause. Thus, there may be many regulations which happen to be enforced by customs, which would not be customs regulations. Indeed, there may be others which happen to be enforced, say, by the police, which would nevertheless be customs regulations within the clause. Thus, I would not accept the appellant's submission summarised in paragraph 16.
So is the approach then that you are not interested in whether under any particular national legislation the regulation is given the label customs, and indeed you're not even concerned with the identity of the body which is enforcing those regulations? regulations.
Correct.
You're simply looking to see whether the regulations are to do with the export and import, particularly the import of goods.
Correct.
Is that your approach?
Yes, it is. Bearing in mind, this is a decision interpreting the English Institute clauses, which is not in the same terms as the clause which this court has to consider today.
Yes. And do you say then that a different approach has to be given to the word custom or term customs regulations in the American clause?
Yes, I do. For this reason, for two reasons, if I may put it this way. There is no similar arrests reference in the English clauses. All it refers to is customs regulations. There are, of course, references to quarantine and trading regulations. In the context of customs regulations, it says by infringement of customs regulations, whereas in the American clauses it says under customs regulations. Now, the way the judge approached it, and as I'll explain later, our case is that when it says under customs regulations, it means any detention under a law described as customs regulations or customs laws, or however you wish to refer to it.
A law described as.
Described as. But the following words, or similar arrests, extends that so that if there is in essence a detention by reason of the importation or exportation of goods in an illegal manner, therefore that would also come within the exclusion.
So in this country, the prohibition on the importation of Class A drugs is not a customs regulation within the meaning of the American Institute clauses.
But it would be, well, it depends, if it's in this country or any country which is not under a law described as customs regulations.
It's not,
like,
it isn't described as a customs regulation.
well,
I mean, you're pinning it to form rather than substance. The regulation has to be described as a customs regulation.
it has to be understood
to
and
come
described.
within that wording for the purposes of the clauses we're concerned with. Is that right?
Yes, but the result is not going to be different from the result.
I understand that. But,
You're absolutely right.
But if that's right, doesn't that really cut across the whole reasoning in the Cleovalos of Rhodes, which is that that's an uncommercial construction, because it would make no difference to an underwriter?
No,
That's what paragraph 41 seems to be saying.
it does, but in a different context, because it doesn't have the extension. All you're left with is customs regulations and nothing more in English clauses. Whereas in the American clauses, you have similar arrests. So one way or another, you have the same result. It's the same, you may have different roads traveled, but you get to the same destination. And therefore, to an underwriter, having the American clauses will do the same job as having English clauses.
I understand.
And
It seems a bit odd that an underwriter who at 10 o'clock is presented by a broker with an English wording, which talks about customs regulations, and at 11 o'clock is seeing someone who'd like to do a deal on the American wording, is expected to realise that customs regulations means completely different things in those clauses. Even what his process of reasoning is supposed to be is that, well, that doesn't matter, because although I give a broad construction to customs regulations in one case and a narrow construction in another, nevertheless the similar wording does precisely the same work in the American clause, which is done by giving a broad construction to the English clause. Just seems rather an old process of reasoning.
well, you may say that, but my lord, I would submit and I would expect that a commercial underwriter, a marine underwriter, a war risk underwriter, would read the clause as a whole and only be concerned about what the net effect will be. It'd be very unlikely, it seems to me, that an underwriter would say, well, wait a second, I'm really very concerned by the fact that it says customs regulation in the Institute clause, English Institute clauses alone, and it has similar arrests in the American clauses. I mean, the chances are that the same result will obtain under both. And I don't think my construction's uncommercial, because my construction gets you to the same place as the English Court of Appeal regarded to be a commercial position in relation to the English clauses. But moreover, it does give effect to the notion under customs regulations. It's referring to a law which is described as such. Now, if I'm wrong about that, and you do have to give a broader construction to customs regulations, even in the American clauses, so any law dealing with the export or importation of goods whether coming under a law described as customs regulations or a law described as something else, that doesn't change the scope of the provision in our case.
I understand your argument, but what exactly do you mean by a law described as customs regulations? Does it have to be in the long title, the short title, some reference to customs somewhere in the relative legislative instrument?
Well, let me put it...
What do you mean by described as a customs regulation?
So long as the parties understand what's being referred to as customs regulations, when I say the parties, anyone who's dealing with these laws on a day-to-day basis, and when it comes to the customs regulations of foreign jurisdictions, it may require expert evidence. But as long as there's an understanding of how it's described and understood, that is sufficient. So it may not have the language customs regulations, but there could be reference to customs throughout the law. So long as it's understood as a customs regulation, that's enough. But just because you might have a separate criminal statute dealing with smuggling or contraband, which is actually not dealt with in what may be described as customs regulations, that doesn't, on one route or another, matter, because smuggling is still concerned with the exportation or importation of goods. So you don't necessarily have to have a law which says the law of customs in a particular jurisdiction. It might be understood as some other law, but on reading the law as a whole, you understand it's a customs regulation.
By which you mean something which imposes duties, do you? Is it really not so much a matter of description, but customs regulation here means something in the narrower sense of imposing customs duties, and then all the work that's done for those which are absolute prohibitions is done by the or similar wording?
Well, except there are provisions in customs regulations which prohibit the importation or exportation of goods, at least without licenses. So that these may still be customs laws. But the important point on the facts in this case is when the experts gave evidence on the fact that there was no prosecution under customs or quarantine regulations, there was no issue before the court that was the meaning of customs or quarantine regulations as understood in Indonesia was any way different from as it was understood under English law. And that's because when you're dealing with customs or quarantine regulations, you're dealing with concepts which are known around the world because they're international concepts. They regulate international affairs, relations between various countries. Therefore, and in this particular case, there was no issue about that. There was any material difference between the way Indonesian law approached customs regulations and English law approached customs regulations.
But if you're right, that it depends upon how the law is described.
Yes.
You could have an identically worded law in two different jurisdictions, one of which was headed customs law, the other of which was headed importation law. And they would, one would be a customs regulation under your interpretation, and one wouldn't.
Well, to be fair, my lord, if you just take your example as being my submission, which is it has to be described literally as customs regulations, if that's the case, then you get around the problem because of the similar arrest provision in these clauses. If, however, on what I actually submit to you is to understand what the law is, whether it's dealing with customs or something else, you don't necessarily just have to look at the title. You have to look at the law as a whole.
So it's not described as?
It's not described
at all.
But it doesn't necessarily it doesn't necessarily have to be described as such. But when I say that, specifically in the title, but it has to be described as such as one has when reading the law, one understands it's dealing with customs.
But your definition of customs for these purposes is it something which prohibits importation without a license or only upon payment of a duty?
Basically,
it's limited to that, is it?
Prohibition or restriction of the importation or exportation of goods into a landed territory. That's what I understand by customs regulations.
Well, that's the Cleovalos of Rhodes definition.
It is, but of course, when you're dealing with smuggling and contraband, it may be dealt with under a criminal statute, and that will come into play. But the point I'm making is, if smuggling is dealt with under a law which is not normally described as customs law, on a fair reading of the law as a whole, then it may not come under customs law, but it will come under similar arrests in our provision.
Well, our laws prohibiting the importation of heroin are not under laws which describe themselves as customs law, but they do come within your definition of laws which prohibit the importation of goods. Are they customs regulations?
Well,
under the American
no, because I do say that you have to look at the law as a whole and see how they're understood, whether they're understood by the relevant jurisdiction as customs laws or something else.
But what's your submission about how they are understood in our jurisdiction? Your definition of what is in substance a customs law is something which prohibits, or includes something which simply prohibits the importation of goods. That's what our law does, doesn't it?
Well, if it's under criminal statute, my understanding of customs law is if it is a law described as such, not necessarily in the title, but on a fair reading of the law, and it deals with the importation of goods, whether by way of restriction or prohibition, it'll be a customs law. If it's dealing with a ban on drug smuggling in a criminal statute, that would not necessarily become under the phrase customs regulations in our clause, although I accept it would in the Cleobulos Roads, but it would be captured nonetheless by the similar arrest provision. Now, if I'm wrong about that, and the reference to customs regulations is equal to the reference to the interpretation given by the Court of Appeal in Cleobulos Roads, then you don't get a dissimilar result. But in either case, you get the same result. But this explains why the Court of Appeal had to take a more expansive approach to the interpretation of the English clauses, because there is no similar arrests extension, whereas that's not needed in the relation to the American clauses. Because, as I say, one way or another, you get to the same result. That's the key point.
Can I just ask you something else? I'm sorry to...
No.
Your submission that this is concerned with things being landed in the landed
Correct.
territory.
Correct.
Would that apply to a prohibition on the importation of explosives?
Well, it's a very good question, and it depends on how the law is framed. And explosives are often...
Well, states would not want explosives in their territorial waters. That's the point.
You mean
there's a danger to a vessel blowing up in port before explosives are landed.
No, if the purpose of if the vessel's being detained because the vessel is going to discharge explosives by way of infringement of customs regulations, or because there's a power given to the authorities under customs regulations, then that will be embraced by the customs regulations. If, however, the vessel's just en route with explosives on board and is detained for other reasons, I don't know why, that may be something completely different. But what customs regulations are concerned with is the entry of goods into a landed territory.
And what about quarantine in relation to cargo? Suppose you have a cargo which is in danger because of infestation or whatever it may be. Perhaps infestation is not the right example, of overheating and the vessel catching fire. And that's a concern, quite apart from whether the goods are landed or not, isn't it?
It may be, but what we're concerned with is the reference to customs regulations.
Well, or quarantine regulations. I think the submission that these two are concerned with problems of landing goods was intended to cover both of them.
Yeah, well, quarantine regulations is concerned with the same thing. So if a vessel enters territorial waters and has a disease on board, it may be quarantined within the territorial waters. It may be asked to leave. But what won't be permitted is the discharge of the cargo or people, if there are people on board with the disease.
But it may be asked to leave precisely because if it's carrying a highly infectious disease, the pilot shouldn't be exposed to it, or because the cargo is positively dangerous.
Correct.
And those are concerns which result in a prohibition on it being in territorial waters.
Correct.
Not merely a concern over whether the goods are landed.
Well, I think realistically, I would submit two possibilities. The vessel arrives with the purpose of discharging goods or people which are bearing disease, and the authorities, health authorities, do not want those goods or people to be landed to spread the disease within the territory. That's what quarantine regulation is concerned with. If a vessel arrives, not with a view to berthing and discharging at a territorial port, but just en route to somewhere else, there may be no need. That's not going to be That's not going to be a detention by virtue of quarantine regulations. Quarantine regulations are concerned with the introduction of the disease to the landed territory, in the same way as customs regulations are concerned with the importation of goods to the landed territory.
Thank you. Sorry, I've held you up for too long.
No,
You're on the authorities.
No, very enjoyable experience. So, so the next point is Elisa Glacial. Which is at tab Authority Bundle 2, tab 19. Page 561. Now, paragraph 31. Now, this is the Court of Appeal in this case was concerned with a vessel which was detained by reason of illegal fishing pursuant in Australian waters. I think it's described as Australian fishing zone, and the purpose behind the act was environmental protection. And it was illegal fishing because they fished without an appropriate license. And the issue was not so much customs regulations, but trading regulations, which forms part of the English Institute clauses. And paragraph 31, the Court of Appeal said the aims of the 1991 Act, that's the Australian Act, are ecological and environmental. So far as the regulations contained within it were passed to further those aims, they were plainly not trading regulations. It's true that the Act's aims also include the preservation and proper management of an important commercial resource, namely fish stocks. In that context, it regulates fishing within Australian waters, whether for pleasure or gain. However, such regulation is not aimed at, or indeed concerned with, the process by which any fish caught are thereafter sold, supplied, or traded. The question to be asked is whether, in the ordinary language and understanding of commercial men, a regulation's purpose is the conservation and management of fishing stocks is a trading regulation, in the sense contemplated by the policy. We do not think the answer is provided by simply asserting that because commercial fishing is a trade to which the regulation applies, the regulation is therefore a trading regulation. And then there is a reference by Mr. Charkham to Arnold and the definition of customs regulations. And if you go to the next page, however, the authority referred to for the proposition in the first sentence in Anita, reference to which shows that the relevant provision of the Vietnam decree under consideration in that case was stated to cover inter alia contraband and refers specifically to those who import or attempt to import products or goods whose import is prohibited by the legislation in force. Thus, while no formal customs code was apparently involved, the nature and purpose of the provision was quite clearly one relating to contraband. So that's the Anita approach. In paragraph 34, and I should just quote Sir Gordon Wilmer's comment in Anita, you can see at the end of 33. The ordinary man, if asked what was the reason for the ship's confiscation, would surely reply that it was by reason of the members of the crew having been caught smuggling. By way of contrast in this case, it seems to us that faced with the same question, the ordinary man would reply that the ship's seizure was by reason of the crew having been caught illegally fishing rather than for trading illegally. Furthermore, we regard the requirement or imposition by the insurers of a warranty as to no illegal fishing as some indication of the parties' contemplation that fishing in breach of local laws or regulations would not otherwise be excluded from the scope of the policy by reason of the exception in respect of trading regulations. We are conscious that our conclusion as to the business-like interpretation of the term trading regulations is contrary to that which the judge thought so plain. However, it seems to us that, taken to its logical conclusion, the judge's unqualified acceptance of Mr. Charkham's submission that if a national law operates to place restrictions on a trade, it is a trading regulation, would mean that exception 4.1.5 has the potential to apply to every local statute or regulation, the effect of which is to prescribe or place limitations upon a shipowner's activities and breach of which may give rise to seizure or detention. If that is so, its scope would extend it to the full range of regulatory measures which may affect a shipowner, whether in relation to the carriage of goods, pollution, health and safety, or conditions of employment. And so the Court of Appeal said that it doesn't fall within the exclusion. Now, the reason I refer to this is the approach adopted by the Court of Appeal by not allowing the interpretation of trading regulations, which is quite broad in that sense, to overcome and supersede the cover available under the policy. And that's an important consideration when considering the interpretation of the exclusion in this particular case. Now, my learned friends refer in their skeleton to a number of times to the Blaine-Richards decision, which is Authority Bundle 4, tab 42. And they do so, I think, at least a couple of times, where they say this authority supports a broad interpretation of customs regulations. And again, one has to bear in mind, and you will recall, my lords, and sorry, my lady and my lords, that the reason for the difficulties with having the goods discharged was the fact that they were fumigated using a substance which was not cleared by the American Food and Drug Administration. And you can see at page 1352, at the top of the page, the very first line says, the second policy was a war risk policy which generally insured against those risks excluded by the FCNS clause. And I'm going to come back to that. This policy, however, excluded damages caused by either seizure or destruction under quarantine or customs regulations, or delay, deterioration, and or loss of market. So there, just to make the point I made yesterday, there is no similar arrests extension in that exclusion. It's just dealing with customs regulations or quarantine regulations. And then the reasoning of the court is at the bottom of the page. Blaine-Richards further argues that even if the detention falls in the FCNS clause, coverage should still be found under the war risk policy. We agree with the district court that the losses resulting from detention fall within the exemptions of that policy, although FDA regulations are not technically US customs regulations, which are issued by the United States Customs Service pursuant to the customs statute set out in Title 19 of the United States Code. We believe that the phrase customs regulations in the war risk policy should be construed in a reasonable manner, which we give proper effect to the intentions and the expectations of the parties. Therefore, detention due to regulations concerning imported food should be regarded as customs regulations. So there, again, a provision which, like the English Institute clauses, does not have the similar risks extension. The court interpreted customs regulations to deal with any law which concerns the importation of goods into the territory of the United States. But what the court does not say is, in terms, you have to interpret it in a broad manner. The phrase is in a reasonable manner, and in accordance with what I would describe as orthodox principles of interpretation. It's broad in the sense of it goes beyond the customs regulations described as such, but it encompasses what an ordinary policyholder, an ordinary insurer would understand to deal with any law dealing with the importation of goods.
It would seem a bit odd, wouldn't it, if that is the American understanding of customs regulations simpliciter, i.e. you are not worried about how the law is described, but with what it is doing. If the result is that then when you appear to extend the meaning of it by adding or similar, etc., actually you're not extending the meaning, because that enables you to give a narrow meaning to customs when it has that addition.
Well, if I make this submission, one has to interpret every contractual provision on its, having on its as a whole provision and looking at it at its particular context. One should not automatically assume that one grasps, for example, the Blaine-Richards interpretation of customs regulation in a differently worded exclusion clause onto the exclusion clause in our case, in the same way one should not assume you graft the Court of Appeals interpretation of the English clauses of the words customs regulations onto the exclusion in our case. My submission is very clearly that if the law is described as customs regulations, And I don't necessarily mean that means it has to be headed customs regulations. And then you have another, then you have a arrest for, or the detention of the vessel for reasons concerned with the importation or exportation of goods or diseases. Then that would come within the similar arrests exclusion. So, but it won't go beyond that. And I'll come back to the word similar arrests when I deal with my construction. But all I'm trying to demonstrate is that when the Court of Appeal in Cleobulos of Rhodes or the Court of Appeals in Blaine Richards is describing how to interpret customs regulations, they are doing so without the benefit of this extension. So they have to find a way which allows this extension, this exclusion, to accommodate what they understand as an ordinary commercial working practice. You don't need to go through that process if you've got a similar arrest extension. You just don't need it because you get the same result. And the other aspect of all this is, and again I'll come back to it, but when one is looking, and my learned friend in a very scholarly fashion looked through the history of the clause, one mustn't assume when parties to a marine insurance contract, both a reasonable policyholder, in this case Greek ship owners, and on the other hand marine underwriters, professional marine underwriters, would necessarily take into account, when dealing with an English law policy, how the words are necessarily interpreted by the US Court of Appeals, or even understand the history of the clause. That would be asking for far too much. All they will see is the clause on the page. It's not like a case where, for example, the appellate courts in this country have given a consistent interpretation to a particular word or meaning, like the word seizure in a war risk policy. And that has been consistently adopted by the courts over time. One can then assume that the parties have contracted on that basis. But we're talking about a much more abstruse history, which is not known, I would dare say, to any, or reasonably well known, to any Greek ship owner and commercial underwriter operating in the London market. Now, my learned friend, as I say, has looked at the history of the provisions. I'm just going to make two comments about that, if I may, and then I'm going to move on to my construction and then my learned friend's construction. The first is this. One has to understand what commercial, and forgive me if I'm telling you something you already know, but when we're dealing with war risks insurance, now if I could ask you to look at the core bundle, tab 19. So the American Institute clauses, which you can see here, these are the whole clauses, not the war risk clauses. They operate in the old-fashioned way of, if I can put it that way, of the old FC&S and SG form. Essentially, one sees at page 375, remember these are not the war risk clauses, at line 70, you'll see the phrase touching the adventures and perils. And you will see the various perils which are referred to: perils at sea, men of war, fire, lightning, etc., pirates, rovers. And then at the end of the second line, line 71, takings at sea, that's seizure, arrests, restraints, and detainments of all kings and princes and peoples of what nation, condition, or quality soever, barratry, and the like. And then, and I think my learned friend referred at the line 73 and 4, which says, excepting, however, such of the foregoing perils as may be excluded by provisions elsewhere in the policy or by endorsement. And then at page 377, you'll see the war, strikes, and related exclusions. And the exclusions A, capture, seizure, arrest, restraint, detainment, or any attempt thereat. And just pausing there, that they are political risks. They're not concerned with armed conflict or hostilities. Then B, taking of the vessel by requisition or otherwise, whether in time of peace or war, and whether lawful or otherwise. And then you've got the perils at C, D, and E, which I would describe as armed conflict perils, hostilities perils. So just pausing there, I appreciate there's an exclusion. And what the war risk clauses do, which I'll come to in a moment, is to provide cover for the perils which are excluded here. And the two major categories of peril under a war risk policy are armed conflict on the one hand and political detention on the other. I mean, it extends to, I say detention, but it extends to seizure, capture, confiscation, nationalization as well. Then if we go to, to fill it out, tab 20, page 378. This is the war risk provision, and essentially, if I can put it this way, it buys back the cover which is excluded under hull clauses. So this insurance, subject to the exclusion set forth herein, covers only those risks which would be covered by the attached policy in the absence of the war risk strikes and related exclusions clause, which we've just seen. So what this clause covers is both classic political risks, which can occur in time of peace or war, but also armed conflict risks or hostilities risks. Now, the reason I mention this is because at various stages in my learned friend's skeleton, and just take you to two references, I'm looking at tab 4, page 80. At paragraph 59.1, my learned friends referred to the supplement to the Code of Federal Regulations of the United States of America, and refers to the relevant provisions which exclude, as you can see highlighted at the bottom of the quotation, excluding arrest, restraint, or detainment under customs or quarantine regulations, and similar arrests, albeit ending with the words or sanctions. But the perils which were quoted previously tend to be all hostilities perils, or armed conflict perils, not political risk perils. And that leads to the submission at paragraph 59.2 and page 81. In the second sentence, line 3, it will also be seen that the exclusion is in the form of a carve-out from a defined list of perils, all of which concern war or warlike hostilities, and do not include other perils which have since been included in some forms of war risk cover, such as strikes and lockouts. And then in paragraph 61 on the same page, what is clear is the exclusionary wording predates the equivalent exclusion in the English clauses, which, as the judge noted, dates from the 1959 version. It also dates from a time when the only perils covered under the US clauses related to hostilities and the like. Now, my submission is that that statement is wrong, and I can take you to the Code of Federal Regulations, which is referred to in this context. And one can see that at this the same bundle. No, sorry, it's Authorities Bundle 4. Tab 51. And at page 1505. And one sees under the heading FC and S clause, so free of capture and seizure, and then there's a warranty free from any claim for loss, damage, or expense caused by or resulting from capture, seizure, arrest, restraint, etc., etc. So that's basically the old FC and S clause, which excludes cover for political risk detention. And then you've got, page 1506, right at the bottom of the page on the second column, touching the adventures provision, which is replicated in the American hull clause that we've just taken you to. It's the old SG form, and you can see, again, references to fire, enemies, pirates, rovers, and also takings at sea, arrests, restraints, and detainments of all kings, princes, and peoples of what nation, etc. And then we come to page 1508, and this is the FC, this is the war risk clauses. It's agreed that this insurance also covers those risks which will be covered by the attached policy, including the collision clause, in the absence of the FC warranty contained therein, but which are excluded by that warranty. So what this is essentially doing is providing cover, or buying back cover, which is excluded under the hull clauses. And then you have the provision which is quoted in my learned friend's skeleton. So these rules, these provisions, these forms, do exactly the same thing as the American Institute clauses do in the policy before this court. No different. The exclusion is not to be read as applicable only in case of hostilities or armed conflict. It also encompasses political risk detention. But of course, as far as the history is concerned, I've already made the point that it's unlikely that the parties to this policy will have had the history of the clause, as far as the American policies are concerned, in mind. But even if they did, it's very unlikely that any of these discussions would have an influence on the true interpretation of the provision. I'm not saying, all I'm saying is it's neutral. I'm not saying it goes either way. Now, what is our case? And I think I've already probably, in answer to my Lord Justice Popplewell's questions, I hope I've explained my case in part clearly, I hope, but I hope it's wholly clearly. But let me just make it good, just so I understand, so you understand. What we say when we're dealing with the exclusion which is concerned with this policy before this court, when it refers to under customs regulations or quarantine regulations, we're talking about an arrest, detention, or restraint which is effected pursuant to powers applicable under customs or quarantine regulations, properly described as such. Now, whether that means that the word customs or quarantine regulations in a title, or that's how it's understood by the local law, that's what I submit that phrase means. The words or similar arrests is basically to be given the interpretation which the judge below properly gave it, which is it must be an arrest under a different law, not properly described as customs or quarantine regulations, but which has the same material, or materially the same, objective or purpose. I'm pausing only because I'm expecting a question, but then I'll move on. If I'm wrong about the proper interpretation to be given the customs regulations, and for whatever reason, this court considers, well, the word customs regulation in this exclusion is to be given the same interpretation as the Court of Appeal gave it in Cleophilus of Rhodes, or as the Court of Appeals in Blaine Richards gave it, then we say the word similar arrest shouldn't be given a different interpretation than given by the judge. You're still looking at the question, is it materially the same in objective or purpose, the arrest? That's the issue there. And when one is considered...
I'm sorry, could you repeat that? So you're saying if customs or quarantine has the same meaning as was given in the cases to which you've referred, including Blaine, but the English case to you,
yes,
which is, one might say, broader, then or similar has what effect?
It's the same meaning the judge gave it. It still has to be materially the same in objective or purpose. That's the phrase she used. I may paraphrase, but that's essentially what she said.
That on that basis, that's to say that customs regulation has
Well, it may be, for example, the way the Court of Appeal approaches the Cleophas of Rhodes is an ordinary person would understand anything to do with smuggling is coming within customs regulations. There may be more abstruse provisions which would not necessarily be understood as coming under customs regulations by the ordinary person, but nonetheless have the same materially the same objective and purpose, to regulate the flow of goods into a landed territory or to regulate the introduction of disease into a landed territory. Maybe seen in a very different context.
What about a freestanding law of forfeiture of goods? We pass a law saying if Russian oil comes within our territorial waters, it should be subject to seizure and forfeit.
No, that would not be covered.
That would not be covered.
Not covered. Because that's not dealing with the regulation of, that's dealing with the imposition of sanctions, for example,
yes,
which is a very different context. And remember, of course, for what it's worth, there was express reference to sanctions in the old American clauses, which was removed subsequently.
But if the law says prohibition on import and forfeiture,
Well, it depends why
it would come within.
Well, it depends. It depends why it's being forfeited. If the goods are being lost by reason of customs regulations, however they're understood, then of course, yes, it comes from the exclusion. If they're being lost because of the imposition of a sanctions legislation, which has nothing to do with customs regulations, because, for example, it's enacting the policy of the relevant country not to deal with certain states by virtue of the fact that they are those certain states, then
countries may have all sorts of reasons for imposing what are, on either side's case, customs regulations, or prohibitions on imports of certain
correct
things. And one of their reasons may be we're going to put a ban on prohibition on imports from certain other countries or goods which have come from another country. Now, is that not a customs regulation?
So I misunderstood. I thought the question was if goods happen to be passing through territorial waters and they're subject to sanctions legislation and the goods were then dealt with as forfeited, even if they're not intended to be discharged and landed in the territory of that country.
No, sorry, it's my fault if I didn't make that clear.
Sorry.
They're brought here.
Right.
There's a ban on importation, but there's also a provision, let's say it's in a separate law, which says they should also be subject to forfeiture. Would that come within similar?
No. If they're being forfeited by virtue of the customs regulations, either because they're being infringed or breached, or for some other power granted by the customs regulations, then that would come within the scope of the exclusion.
You've got you've got two separate laws.
Yep.
One says prohibition on importation.
Yep.
The other, quite separate regulation, says and shall be subject to forfeiture. Would that be or similar on all cases?
Sorry, or similar. I thought I was just stressing my customs regulations, but if it's a similar arrest,
no, I'm on my lord's point. He was asking you what could be covered by or similar if customs regulations is wide enough to cover all bans on importation.
If the reason the forfeiture takes place is because the opportunity arises by virtue of customs regulations, then yes. But if, just to take the other example, which I was labouring under, which a misunderstanding I was labouring under, if it just so happened the ship was passing through territorial waters and the naval authorities in those territorial waters took over the ship and forfeited everything on board.
That wasn't intended to be.
No, but just to contrast the position, that would not come within the similar arrest extension, because it would not be materially the same objective, purpose, materially the same purpose and objective.
Because your main interpretation of customs and quarantine relates to the effect of landing the goods, and you say therefore or similar also, although it may be labelled differently, is also concerned with landing the goods.
Correct. And as far as quarantine is concerned, it's the introduction of disease. Sorry.
So what about a law which says that a ship which has a cargo which is infected with disease passing through territorial waters may be arrested and the cargo destroyed, so that it's a public health issue, it's just not a
No, it's public health, but if it's not
similar to quarantine,
no, because unless what's being regulated is or protected against is the introduction of the goods or the disease into the territory, or the disease into the territory. If that's what's being, if it's just being done for other purposes, for example, out of assistance to a destination port, at a request of a destination port's government authority, that'd be different. They'll be doing something different. But if the purpose is to regulate the introduction or prevent the introduction of disease into the land, the territory, then that would be caught, either within the quarantine regulations or within the similar arrests. But if it's just happening to pass through, exercising a right of innocent passage, then that would not be. And so when it comes to this exclusion, one has to focus. What I do say, one has to be very wary of grafting interpretations given in context of differently worded provisions, whether in England or the United States, onto this clause. I'm not saying you shouldn't do it necessarily, but I would advocate you shouldn't. Well, so I am saying you shouldn't. But if I'm wrong about that, then you still get to the same result. But there are three aspects of this provision one has to consider. The first is the exclusion applies in relation to detentions or arrests under customs or quarantine regulations. So the word under customs regulations. There are two aspects there. The third aspect is the reference to similar arrests.
so I missed that, the reference to...
So the relevant words are under, number 2, customs or quarantine regulations, number 3, or similar arrests.
Yes, all similar, that's what
Yeah.
I said.
So now the reason those words are important is because the word similar, I beg your pardon, and similar, I'm so sorry. The words and similar need to be construed by reference to customs or quarantine regulations. There is no other reasonable interpretation to be given to the words and similar in those circumstances. What the clause does not say is arrests under customs or quarantine regulations or under any other regulations. Or it doesn't say for any other reason. It says or similar arrests. And similar arrests. And I'm going to submit the word or and doesn't really matter very much in these circumstances. So it's and similar arrests. So one has to understand what similar means by reference to customs and quarantine regulations. And in doing so, I would submit you should have regard to what the Court of Appeal said in Elisa Glacial when looking at the meaning of trading regulations and whether they apply to the Australian Act dealing with illegal fishing. One should not give it so wide an interpretation to deprive it of substantially or political risk. It's an important consideration. So what does what we say similar means in these contexts is what the judge said. It has to have materially the same objective or purpose. And for what it's worth, I appreciate that in different contexts, but we have referred now, Skeleton, to an authority dealing with aggregation clauses, where it says similar matters or similar transactions, and a charter party provision, which refers to a charter party form or similar. In both of those cases, the court was concerned with identifying there being a substantial similarity, at the very least, between the described item, which is customs or quarantine regulations, or in the charter party context, ABSA, and then whatever else is allowed by the word similar. It can't just be something which is, it has to be closely related. It can't be something which is not closely related. And as I say, if the intention were to introduce a much broader provision, then you would put it in a different way. And as my learned friend said yesterday, there are policies available where you can get a complete exclusion in relation to this if a vessel is detained under the law or criminal law of a particular state. Not just by reference to customs or quarantine regulations or similar, but much more broad. And the reason the judge suggested why customs or quarantine regulations are referred to is because they are more likely to be treated as run-of-the-mill, ordinary reasons for detention, not something out of the, which is unusual. And of course, in this particular case, what we're concerned with is the vessel's detention overnight in territorial waters because it didn't get customs permit, harbour master's permission or to stay overnight. It had no cargo on board. There was no allegation of smuggling or carrying contraband. It was the vessel and the master were acted against pursuant to a shipping law which regulated navigation, regulated what could or could not be done within the territorial waters. Now, to extend the notion of, to allow the word similar arrest to apply to those circumstances, it goes far beyond what any person reasonably interpreting this exclusion would understand. This was an unusual risk. It was the first time that this particular period where the Indonesian authorities adopted this new policy campaign.
Does it make a difference to the nature of the arrest and detention, as to say whether it is similar or not, according to whether it happens in February 2019, when nobody knows that the Indonesians are going to behave in this way, or in, say, April 2019, when a foolish master drops anchor in Indonesian territorial waters, when actually everybody knows that's a foolish thing to do.
No, it makes no difference.
So the fact that it comes out of the blue then is not relevant to whether it's similar.
No, but it does highlight how odd it would be. So the judge made this point. Customs and quarantine regulations are, I wouldn't say routine, but they're a normal part of trading goods into a particular territory. What happened here was unusual. So to test the construction, one has to look at the out-of-the-blue nature. It'd be highly surprising if this sort of event would give rise to an excluded peril. The mere fact that it's been done many times, and a vessel without adequate consideration anchored in territorial waters, knowing, perhaps not even knowing, but should have known, ought to have known that this sort of thing could happen, doesn't change the interpretation of the skeleton, interpretation of the exclusion. But what I would say is, it does test whether or not the exclusion should or should not be applied in the extreme circumstances of this particular case, because these are not ordinary events. And moreover, just a matter of interpretation, have nothing to do with the export or importation of goods, have nothing to do with the introduction of disease into landed territory. Nothing.
Do we have evidence, or did the judge have evidence about whether these were ordinary events? In the sense, I appreciate that there was evidence that there had been a change of attitude in relation to the Indonesians, but presumably around the world there are all sorts of places where you can't just moor up wherever you like. And I don't know whether there was evidence about that, and that just goes to your point about whether this is an unusual circumstance when one's looking at the policy as a whole.
I can't say there was evidence before the court, unless I'm told otherwise, whether this was completely exceptional as far as the jurisdictions of the world are concerned. I dare say if you're in a jurisdiction where there's a state of war or a state of sanctions, that might be different.
That would be different.
Yeah, but just in ordinary trading nations who get on with each other, as far as I can tell, this was a shock and a concern. And I think that was essentially the evidence of the ship owners and the master in this particular case. This was a complete surprise.
But the focus of this clause is on the nature of the regulations.
Correct.
And they may apply in a wide range of different circumstances. So you may have the same regulations, which on the one hand prevent anchoring just inside territorial waters when you're in transit with no cargo, but the same regulations would prohibit you from landing your cargo at a particular jetty without the permission of the customs. And whether or not the exclusion applies is determined, is it by reference to the regulations as a whole, rather than the particular circumstances in which they were
Well, it's to be
applied.
interpreted by reference to what is understood as customs regulations, which is, I would submit, and I think, for example, Court of Appeal in Cleophas and Rhodes said, is concerned with the rules concerning the importation of goods. Whether it's prohibition or restrictions or however you wish to describe it, that's what it's concerned with. And in this particular, in that particular case, Lord Justice Clark concluded in paragraph 43 of his judgment that just because the detention takes place under customs law doesn't mean it's within the exclusion, and vice versa.
Just because it takes place
under a law described as a customs law. I can take you back to the reference, paragraph 43 of the Delos Shipholding.
I thought he was saying just because it's done by the customs authority.
No, I think he said.
But I may have misread.
I think I don't want to mislead my lord, so make sure I've got it right. I think I may have misunderstood it. No, I think it's the agency who's enforcing it, right? So it's my fault.
You say that customs and quarantine refers to the import of goods or diseases into the landed territory. I suppose you could say that even if or similar extends it wider than that, it is at least limited in that it must have to do with things or people that are on the ship.
I don't submit that, but it could. But even if one adopted that construction, it wouldn't apply in this case. Because the reason the vessel was detained was not to do with disease or goods on board the vessel, whether or not it was to be landed. It was to do with the mere fact that the vessel was in territorial waters.
But it was to do with a decision by the state that it would exercise its sovereignty.
Yes, but that would not be within the exclusion. And I'll come back to the sovereignty issue later. But that would, so even if my lord's question is correct, even if that the way in which should interpret the clause is correct, that would not apply in this particular case. But I don't think it would go that far, because the very notion of customs is the entry of goods into landed territory. It's not to do with the entry of goods into the territorial seas. Same with the disease. Yep. I mean, the way the judge began her judgment, which I say is very clear, and I adopt the construction my lady below adopted. She begins the judgment by talking about this as an illegal parking case. This is where the vessel is where it shouldn't be because it didn't get clearance, but not because of anything on board the ship. And no matter how broad an interpretation you give to the words customs and quarantine, what that is concerned with is something on board the ship is going to go into the landed territory, whether it's disease or goods. But here, there wasn't even an allegation of the vessel carrying disease or goods which were to be expected to be discharged into the landed territory. It was merely the fact that the vessel had no goods on board. It was merely the fact that the vessel was there without permission. Now, my learned friends in their skeleton made a couple of comments, which is the judge didn't give a sufficiently broad interpretation to the word similar arrests, or in another paragraph, it was an unduly narrow construction. I hope I've dealt with those submissions. There is an additional point which is made, which is that the judge considered that the words "not arising from actual or impending hostilities" in the exclusion are not redundant on her interpretation, and she's absolutely right about that. There are many customs or quarantine regulations or similar arrests pursuant to other laws which are introduced in wartime conditions. So even on customs, you can have laws dealing with trading with the enemy, regulating black market goods, and the like. You may not see those in the same way, in the same form, during peacetime. There is no reason to disregard the not arising from hostilities on my lady's judgment below, or interpretation below. And then I'll come to the two constructions adopted by the insurers and say why they're wrong. The first construction, as I understand it, is concerned with detainments. The way it should be interpreted is that it covers any detainment or arrest under the ordinary peacetime local laws of the jurisdiction, rather than some sort of political interference. But the exclusion will not apply if it arises from actual or impending hostilities. So we're talking about peacetime regulations alone. Now, the first thing to say is, if the intention, there are two aspects to this. One is peacetime regulations, and the second aspect is, but that doesn't apply to political interference. But as regards the first, if the intention were to say that there be no cover for any detention under peacetime regulations, it could have easily just said that, either by saying detentions under any regulations, not arising out of hostilities, or it could say a detention under customs or quarantine regulations, or any other regulations. It doesn't say that. It says or similar arrests, or and similar arrests. The second aspect of political interference. Now, yesterday, my own friend referred to, you might get a scenario. I think she gave 3 examples, and for your reference, it's pages 58 to 59 of the transcript of yesterday, where the relevant authority doesn't rely on any law at all, just snatches the vessel, detains it. The second is where the detention is wholly unlawful, and then my learned friend referenced to the Silver decision, where it was in bad faith. And that was where, even though a judicial or a judge sought to use the local laws to detain the vessel, was actually doing it for corrupt purposes. And then the third was what I think she describes as a theoretical detention under local law, but by reason of political interference. Now, one has to be very careful about this, because the courts have considered what, in the context of customs regulations, what infringement of customs regulations means. Just because an insured can prove that the local authority acted without jurisdiction or unlawfully by itself doesn't stop the exclusion applying. So if the local authority is acting in bona fide, so has just made an error of law, and the vessel has been detained as a result. So, for example, the local authorities detained the vessel, believing it's under the customs regulations, but they had no right to do so. But that was a bona fide error. That would still come within the exclusion. So when the judge considers this issue, I think it was just looking at core bundle, tab 8. And I believe it's page 177. Sorry, 176, paragraph 115. Mrs. Justice Dias is addressing the wider construction argument here. And she says the insurer's second suggested construction was that in addition to arrests under customs and quarantine regulations, the exclusion covered detainments which were under regulations but not arising from actual or impending hostilities, so peacetime regulations. As she explained, this differed from her her first suggested construction by distinguishing between ordinary peacetime regulations, which gave rise to criminal penalties, and the arbitrary exercise of executive power without legislative basis, and for purely political purposes, such as occurred in Silver. On this construction, the former but not the latter would be excluded unless war-related. She submitted that it was unsurprising to have a wide regulations-based exclusion of what was primarily a war risk cover. Now, pausing there, that submission doesn't make sense because one of the key aspects of war risk cover is political risk detention. I reject this construction also. In my judgment, it differs very little from her primary construction, since the result is still to restrict cover for detentions to war-related cases when the assured would otherwise be covered for politically motivated and other non-war-related detentions. The likelihood of a case such as the Silver, where the vessel's detention was not war-related, or was not under any regulation either, seems to me to be too remote to be allowed to dictate the construction of the exclusion. Now, the judge was right about that. As far as I am aware, the only time that argument to evade the application exclusion has succeeded is the Silver. It was tried in the B Atlantic. It was also attempted, I have to say, by myself in another case called Antares, but the judges in both cases rejected those arguments. It's a hope, what one is looking for, as Miss Justice Flo said in B Atlantic.
You tried it in this case too, didn't you? Saying it was all the Navy people trying to get a bribe.
That was certainly one of the residual submissions I made. But there was a good basis for saying it, my lord, and I felt wholly satisfied with myself in making that submission. But I'm not pursuing it on appeal, however that's understood. In those what the judge is saying is this allowance for purely political detentions doesn't count for very much when one is dealing with regulations-based exclusions. Because most detentions, in my what it's worth, in my experience, is most detentions are pursuant to a particular law, no matter how they're drafted. So even with the first Gulf War, when as in Robust Garlison Mountain, when the dredging fleet was detained in Iraq, at a time when Iraq had invaded Kuwait, the Iraqi government passed a law which was called Law 57, which operated to seize all foreign property. There's always a law. In that particular case, that was regarded as an operative peril. Sorry, a peril didn't have an operative consequence. So one really can't take too much from that. I would add, I think at one point in my learned friend's skeleton, it's said that the judge's interpretation doesn't allow for politically motivated detentions. Now, she did say that, the judge below said that, in the context of the first construction, paragraph 114 of the judgment. But I'm not sure she said it as much in relation to this paragraph. But my lady below was absolutely right, which is that the very notion allowing for political detentions by himself doesn't really give you very much coverage. So the reason why the wider construction is right, because essentially, sorry, the wider construction is wrong, and why the judge was right to reject it, is because it would be limiting detentions to wartime detentions, and possibly arbitrary detentions in peacetime. It would remove most of the political risks available in peacetime from the insureds. And if that had really been the intention, there were other better ways of expressing the exclusion. So that's the wider construction. And then I want to come on to the narrower construction. And this is identifying whether or not there's a common genus between customs and quarantine regulations and the shipping law under which the vessel was actually detained in this case. And the way I think it is put is, by my learned friends, is, I don't know which order it's done, but either the common genus is sovereignty or national security, which applies in relation to either law, or it's the requirement of clearance. Or maybe they're just two sides of the same coin, I don't know. And then, just so it's clear, the judge dealt with this by way of summary in her dismissal of the application for permission to appeal, which one can see at tab 9 of the core bundle, page 240.1. The construction of exclusion E is a question of law for the court. This is paragraph 1. The construction accepted by the court broadly equated to one of the defendant's alternative suggested constructions, which is the third construction. The court concluded that the arrest in question was not similar to an arrest under either customs or quarantine regulations. This was a finding of fact which was justified by the evidence. It's not reasonably arguable that either of the constructions which was rejected is correct. And she adds a particular comment about the market. Then, so when one goes back to the judgment, the essence of the decision is in paragraphs 119 and 120 at page 178 of the And when Mrs. Justice Dias says, it seems to me that this is broadly correct, she refers to Ms. Hopkins' third suggested construction, which is not very different from my construction, and my construction was a detainment must be similar in nature to a detainment under customs or quarantine regulations. And the way the judge put it was, is this: in my judgment, second sentence, an arrest, restraint, or detainment is similar for the purposes of exclusion E if the underlying purpose and objective of the arrest is materially the same as the underlying purpose and objective of an arrest under customs or quarantine regulations. I therefore accept the submissions, or my submissions, that exclusion E is properly construed, arrives in a different way at the same result as clause 4.1.5. Under the latter, the effect of the Cleobulos of Rhodes and the ANITA is that customs regulations is to be construed broadly as extending beyond simply matters of customs duties to anything regulating exports and imports. In the absence of any similar wording, this was the only way in which the clause could be construed to cover things to do with smuggling. By contrast, exclusion E has expressed similar wording to which effect can be given by construing it to cover arrest for a breach of any regulation, which in substance equates to a customs regulation, as construed under English law, whether the arrest itself is made under a customs regulation or something. And then my lady refers to various the actual wording of the provision in paragraph 120. Now, so what the judge then did is made a number of observations at page 179. And paragraph A, it is the substance and character of the regulations which is important rather than the way in which they're promulgated or enforced. And then there's a reference to Lord Justice Clark's comment at paragraph 43, which is the agency comment, which I think my Lord Justice Popplewell referred to before. Accordingly, I reject insurers' rather faint suggestion that it was sufficient that the regulations be formally or procedurally similar to customs or quarantine regulations. I did not find appeals to the Eustem Generis rule or the maxim nos iter socies of particular assistance in elucidating this question. For one thing, it is difficult to spell out a genus out of two specified matters, and despite agreeing with Miss Hopkins that customs and quarantine are often referred to in the same breath, I can see no compelling reason why the court should strain to find a genus where none naturally spring to mind. More likely, in my view, that customs and quarantine regulations are simply classic examples of regulations under which a vessel is likely to be detained in the ordinary course of events, because they are regulations with which she will necessarily have to comply every time she puts into port. I therefore conclude that there is no meaningful genus which links customs and quarantine regulations, and that it is sufficient for an arrest to be similar either to an arrest under customs regulations or to an arrest under quarantine regulations. And then, the question is one looking for a common theme just in terms of sovereignty and national security? Now, that can't be right, I would admit, because most laws are often cite, particularly in Indonesia, cite national security and sovereignty as relevant considerations, and whatever the laws are. They're often, and it's obviously every law is an expression of the national sovereignty of a particular state. Just to say that national sovereignty is the issue, with the similar theme, the similar genus, doesn't get you very far in terms of identifying the scope of the clause. If you allowed that high-level genus to dictate the interpretation of the provision, you would be left with almost no peacetime cover for detentions under this provision. And the judge dealt with this at paragraph 125 of her judgment, page 182. I cannot accept, sorry, I beg your pardon, 124. Given these features, Ms. Hopkins submitted, and when I say these features, the judge has gone through customs law, quarantine law, and shipping law in paragraph 123 by reference to the submissions of my learned friend. And then at paragraph 124, given these features, Ms. Hopkins submitted that there was a close connection between the purpose of the relevant provisions of the shipping law, under which the vessel was detained, and various parts of the customs law and quarantine law, and the detention under one was accordingly similar to detention under another within the meaning of exclusion E. I cannot accept this submission, which seems to me to assert similarity at far too high a level. Many laws can be said to relate to national safety or security or the upholding of national sovereignty, which they have nothing to do with customs or quarantine. For example, laws against public protest or anti-terrorism legislation. National security, safety, security, and sovereignty in themselves are therefore too unspecific to amount to a unifying factor which justifies a finding of similarity. Even a desire to regulate who or what passes in or out of national territory could also be said to underpin laws which have nothing to do with customs or quarantine, such as immigration, asylum, and nationality laws. And one could extend it to sanctions laws, if there are laws implemented in pursuant to national sanctions or international sanctions. So one has to be very, very careful in identifying a genus at that high level, because you are prone to cover almost anything. The alternative way, I think, my learned friend has put it is, well, you look at it in terms of what laws require clearance, and if you fail to get clearance, therefore you're detained under those particular regulations. Now that can't be right, I would submit also, because clearances, approvals, consents of local authorities can be given for anything, whatever the laws are, not just customs and quarantine regulations. And they can be given by different agencies and at different times. What is the connecting factor? It can't just be whether it's environmental, whether it's illegal fishing. So remember Eliza Glacial, that was a case where you could have fished legally in an Australian fishing zone if you got a license. But there was no license obtained. And therefore, but that still didn't come within the exclusion.
A different exclusion.
Trading regulations, yeah. But still was an exclusion which referred to customs and quarantine regulations. Not similar arrests, I appreciate. But it just gives you a flavour of how this, whether the obtaining of clearances or of licenses can be sensibly regarded as a common genus. An easier way of dealing with it is a detention because there's a failure to obtain consent from the local authorities. But that's not what it says. So let me put it another way. There can be requirements of clearances or approvals or consents in relation to immigration, as the judge says, environmental protection, port state control. So a vessel can be detained because something's wrong on board the vessel and hasn't got clearance to leave until those things are corrected. It has nothing to do with entry of goods or entry of diseases. It could be blacklisting or sanctions applications. And you can get licenses for all these things or approvals for all these things. But that can't be the common theme because the requirement of clearances is not even referred to in the exclusion. So I hope I haven't gone in too circuitous a route, but the end point should be, and I hope it's fairly understood, that I submit that the judge got the interpretation of the exclusion correct, and I would ask you to uphold her interpretation. And on any view, however one approaches it, whether it's on the wider construction or the narrow construction, that it does not apply. Sorry, I beg your pardon. However it refers to it, interpreted properly, it doesn't apply to these facts. these facts are not facts which come within the ordinary understanding of this particular exclusion. It has nothing to do with customs, has nothing to do with quarantine, has nothing materially similar to it. And therefore, the appeal on this ground should be dismissed. Unless you have any further questions, my lady and my lords, I'm going to move on.
Yes, and I'm becoming a little bit concerned about the time, so it's good that we're moving on. We'll
Well,
try not to. We'll try not to.
I have this, so it's just so it's clear. We understand we're going to sit until 4:15 with the normal hour for the short adjournment, and I've indicated my learned friend I'm aiming to finish around 3:30. So that gives.
I'm just concerned also about the issues of the respondents' notice.
I will be addressing those as well.
Okay.
Yes. I mean, some of these response notices can be dealt with reasonably quickly. I hope, and I think my learned friend doesn't disagree with that.
Well, they haven't been dealt with
By me.
On that side of the court either. So.
No, I appreciate that.
Okay.
All I would say is my lady's concern is
It's
well
all
in mind.
sorted out. Okay.
Yeah, no, I wouldn't say it's all sorted out. it's well in mind. So,
Okay.
and I'll do my very best to adhere to it. But of course, if you want me to hurry up, I will do so. And if you want me to slow down, I'll do that as well. But I'm
Do carry on.
I will carry on.
At least.
So I'm going to move on to fair presentation, which is the second issue before the court. So as far as fair presentation is concerned, of course, in any fair presentation case, the burden is on the insurers to prove that there's been non-disclosure of a particular circumstance. That circumstance is material. The circumstance was within the claimant's knowledge, and the non-disclosure induced the writing of the policy. And under the existing law, introduced by the Insurance Act of 2015, inducement is not only a precondition to the entitlement of the insurers to exercise a remedy, it also, depending upon the facts, dictates what the remedy is. And my learned friend says it's a menu of remedies. It's not a menu in the sense that the court can select any of them, or the parties can select any of the any of the remedies available. The remedies are specified depending upon particular circumstances, so they're fixed. Now, even if the insurers can prove all these elements, and we say they can't, there are still issues concerning affirmation and the impact of it being a composite policy. Now, the insurers appeal on questions of knowledge and inducement. If they fail on my submission, on either of those grounds of appeal, then the appeal also fails. Now, as far as the non-disclosure is concerned, it concerns criminal charges which were brought against Mr. Bayraktaris, who was a nominee director of Delos, the owner of the Win-Win. He had been charged with a criminal offence relating to drug smuggling in connection with another vessel outside the claimant's ownership or responsibilities. It had nothing to do with the claimants at all. The charges were brought in early 2018, and as the judge recorded at paragraph 32 of her judgment, no steps were taken against him by the time of the trial. So the charge has been brought, but that was it. And as my learned friend said yesterday, the
relevant fact is no steps taken against him by the time of the presentation. Surely the time of the trial is relevant.
No, but she's still recorded. Well, as
She
far as
recorded it,
yes.
yes, but so far as the breach of the duty is concerned,
Yeah.
one looks at the position at the time of the presentation, surely.
Correct. In terms of identifying materiality and inducement, that's absolutely right. Of course, knowledge is a separate question.
Of course.
Now, and as my learned friend said yesterday, these charges are no longer pursued, and it was described by the court as there being no evidentiary basis for them. So that's just, of course, what my Lord Justice Mail says Absolutely correct. Now, there were other non-disclosure arguments which were advanced by the insurers prior to trial, but they were abandoned by the time of the trial. So we're left with this particular non-disclosure argument. The reason I mention that is because it's relevant in the context of affirmation, which we'll come back to later. Now, the allegation before this court today is limited to Delos. Before the judge, it extended to NGM as well. So the notion was that Mr. Bayraktaris was senior management of NGM as much as Delos. Now, as far as senior management is concerned, my learned friend very kindly has taken you to the relevant provisions of the Insurance Act. What I would ask, I'm going to take you to the explanatory notes and then the Law Commission report very briefly. I know you've been to it. I just want to point out certain provisions. And you'll see those at Authority Bundle 4. Tab 46. And it's looking at the first page, 1398. And I think yesterday my Lord Justice Mayles asked the question, is it permissible to look at the Law Commission report? And there was certainly no issue before the judge. That no reference.
I asked about the purpose for which one.
Yeah. I would just point out paragraph 5 of the explanatory notes, which are the Treasury notes accompanying the Act. And what they say is that the main provisions of the Act give effect with some modifications to the recommendations set out in the Law Commission report. So the explanatory notes are plainly prepared with regard to the Law Commission report. Now, it doesn't say, obviously there are modifications, so one has to be alert to what those modifications might be. But it's still legitimate, I would suggest, that one should have regard to the Law Commission report. And then if we go then to page 1404, again, so what I'm approaching, I should make clear, in the first instance, is the question of actual knowledge and whether or not Mr. Bayraktaris is part of the senior management of Delos. And then there are 2 points I want to make, and there are points which I think were addressed yesterday. But paragraph 54, where the notes state that the senior management is likely to include members of the board of directors, but may extend beyond this. When it says that likely to include board of directors, it means that it doesn't necessarily have to include a director. There's nothing inherent in the role of an appointment as a director of a particular company which automatically leads to that person being a member of the senior management. If one looks at the formulation of the definition of senior management in the Act, it's entirely factual. The question is, does a particular person have a significant role in decisions made as to how the company's activities are managed or organized? That's a factual question, not a legal question. So just because one is an appointed director does not lead to the automatic conclusion that that person is a member of the senior management. That's an important consideration. And in paragraph 55, the explanatory notes go on to say that in the third line, those categories of persons are expected to be construed relatively narrowly, but are capable of being applied flexibly. So the whole point of this exercise, and I'll make this good in a moment, is to fix the knowledge of the company by way of attribution to the members of the senior management by focusing on high-level or key individuals within that senior management. Because the danger is, the broader the interpretation given to the phrase, the more burdensome the obligation of disclosure becomes as far as the duty of fair presentation is concerned. And one of the objectives of the Act, as explained in the Law Commission report and the explanatory notes, is to make the law more insured-friendly and less insured-friendly. Now, if one, and as the judge said at paragraph 195 of her judgment, whilst directors normally are expected to form part of senior management, that doesn't necessarily mean they have to. Now, if one goes to the Law Commission report, next tab, page 1431, paragraph 8.58, when we formulated the definition of senior management for the purposes of the draft bill, and this is Law Commission speaking, we began by looking at the 2007 Act. We thought that the definition there was wider than it should be in the fair presentation context. Unlike the 2007 Act, we intend to catch high-level senior management, but not regional or middle managers, involved in only part of the organisation. We wish to follow Gibson and Barton by including only those people with the management of the whole affairs of the company, not an agent who's to do one thing or a servant who's to obey the orders and do another, but a manager who is entrusted with the power to manage the whole of the affairs. And then, of course, as we've seen, the Law Commission considers various different types of entities which don't include the entity which we're concerned with today. Now, Mr. Bayraktaris was a director of Delos, not of NGM. And of course, NGM has an independent interest as a co-insured under a composite policy. Now, the insurer's case is, I think they accept that Mr. Bayraktaris did not manage the activities or did not have a significant role in deciding how the activities of Delos were managed, but they do say he had a significant role in deciding how the activities of Delos were organized. And the way they put it, I think, is at paragraph 16 of their skeleton, which is at core bundle 4, tab 4, page 65. Paragraph 16, yes. And they say the judge misconstrued what is meant by organised under section 4.8c. Must mean something different from managed, hence the word or. Had the judge properly construed the word organised, she would inevitably have concluded that because Mr. Bayraktaris completed the paperwork for vessel acquisitions, disposals and finance, the opening of bank accounts, the declaration of dividends, the grant of powers of attorney and the issue of share certificates, he did have a significant role in making decisions about how Delos activities were organised. The fact that he may have acted on someone else's instructions when it came to buying or selling vessels did not mean that he was not involved in how the affairs were organised. It simply meant he did not have a role in how they were managed. And the judge's distinction between organisation of the activities of the company and the organisation of its paperwork is one without a meaningful difference, when the only activities of the company in question, an SPV, are the legal and financial formalities associated with vessel ownership. And therefore, so the activities identified are those concerned with the legal and financial formalities relating to ownership and paperwork. Now, the argument is not because he had a significant role in those activities, he was part of senior management, even though he had no role at all in the operation of the vessel or the procurement of insurance. Now, this is wrong, we say. If a nominee director who was obliged to act in accordance with instructions, as a judge found, had no operational or insurance role, he cannot be treated as managing, as having a significant role in deciding how the activities of the company are managed or organised. The insurer's case seeks to impose an overly formalistic approach, the assessment of senior management. Delos is a single vessel's SPV, which was, as a judge found, commonplace in the shipping industry. The third parties dealing with Delos would have regarded themselves as dealing with the NGM group, not Mr. Bayraktaris, as the judge also found. The question, therefore, is, can Mr. Bayraktaris' role, as far as paperwork and formalities, really be considered to be the activities of the company? And we say no. Even if they are to be regarded as activities of the company, they are not the principal activities of the company, they are merely ancillary. But as the Law Commission made clear, when identifying senior management, we're looking for people who decide how affairs or activities of the company are managed and organised. Not, I think my learned friend used the phrase, when the person involved makes practical arrangements to get things done. That's not the issue. The whole approach of the insurer's argument is out of kilter with Section 4.3, we say, which is to attribute actual knowledge to key or high-level individuals within the relevant organisation without being overly prescriptive. It must, and therefore justifies, a case-by-case interrogation on the facts and the evidence which the judge carried out in this case. Now, if one goes back to the judgment, Core Bundle 8, page 206, at paragraphs 196 to 199, the judge makes a number of findings based on the evidence and based on an assessment of that evidence. Now, the first point to make is the judge found that Mr. Bayraktaris was contractually obliged only to act on the instructions of the Mendreas family, as acknowledged in the letter of indemnity, which is in the supplementary bundle of the court wishes to look at it. Now, my learned friend made a point yesterday, as far as at least the directors of English companies are concerned, that somehow or other that may be an infringement of how a director may act, may be an unreasonable or illegal giving up of powers which are granted to the director to look after the affairs of the company. And that may well be as a matter of English law. But this was Mr. Bayraktaris, who was appointed as a director of a Marshall Islands company. The relevant indemnity agreement, which required him, which he signed, which required him to act on the instructions of NGM, or the Mendreas family, was presumably governed by Greek law. If there were an issue about the legal effect of that, it should have been raised by the insurer, but it wasn't. There was no argument below, not even pleaded, and therefore we had no opportunity to advance any evidence on this if it became an issue. The judge made a finding that Mr. Bayraktaris was contractually obliged to act on the instructions of the engineering group, full stop. Whatever the position under English law in relation to an argument which was not advanced below has no part to play in this appeal.
And you said that extends to what was said yesterday also about inevitably there would be underlying fiduciary duties as a director.
Correct. Under English law, yes.
Well, that wasn't said, but that was understood.
Yes. Just pausing there, if the judge is correct about this, and this is a decision made on the facts, and there was no evidence really advanced to the contrary by the insurers, this identifies one of those areas which counts Mr. Bayraktaris out of senior management, because the Law Commission say if you're acting under orders in these circumstances, you are not going to be part of senior management. Paragraph 8.58. The judge also said the purpose of appointing Mr. Bayraktaris as a nominee director of Delos was for convenience, so he would be available to sign transactional documents quickly and as when required, mainly in relation to ship sale and purchase transactions. Mr. Bayraktaris had, so the judge found, had no substantive involvement in anything to do with NGM's group insurance, at best only acting as a postbox. He was effectively discharging, so the judge found, an administrative function for the purpose of transactions involving Delos. He did not himself operate any bank accounts or speak to the company's auditors. He exercised no independent judgment in relation to the operation of the company, had no decision-making power. He was a vehicle for the execution of decisions made by NGM and the Mendreas family. And this arrangement, the judge found, was commonplace in the shipping industry. He was not seen as the public or visible face of Delos. That was NGM. And therefore, the judge concluded he was not part of the senior management. And we would say that this was the judge applying the definition of senior management on the facts and on the evidence. And there's no reason to assume the judge has got this decision wrong. As I say, there's nothing in the definition under section 4.8 which indicates that a particular person with a particular title should be regarded automatically as a senior management. The legislation could have said that, but it doesn't. Both parties accepted this is a question of substance rather than form, and the judge so held. The judge also held that Mr. Bayraktaris played no role in the making of decisions as to the activities of the Delos, in how activities of Delos was managed, but there's no appeal on that finding. As I say, the appeal is in relation to organisation. Now, the judge considered the argument that the activities of Delos were limited to purely financial and legal matters. This is paragraph 203. You can see the argument at the top of the page in paragraph 202. Mrs. Justice Dias says, ingenious though this submission was, it smacked somewhat of desperation. First, I'm by no means persuaded that it's appropriate to confine the activities of Delos quite so tightly. Delos owned the vessel, and to that extent, its activities include operating her for profit. Now, pausing there, my own friend took you yesterday to the Articles of Association, which makes clear what the scope of the intended role for Delos was, which includes commercial operation and chartering the vessel. The judge goes on, Mr. Bayraktaris played no role at all in organising that aspect of Delos' activities. It was all handled by NGM and FML. But even on the narrower view that its activities were only financial and legal, the truth was that Mr. Bayraktaris did not make arrangements for anything to happen. He did not arrange when or how Delos would buy or sell vessels or obtain finance. He simply acted on someone else's instructions to the arrangements to be made, as to the arrangements to be made. I regard it as irrelevant that he may have completed the paperwork for vessel acquisitions, disposals of finance, the opening of bank accounts, the declaration of dividends, the granting of money, powers of attorney, and the issue of share certificates. First, the Section 48C is aimed at the organisation of the activities of the company, not the organisation of its paperwork. In other words, looking at the substance of what the company does, not the administrative formalities. Whereas otherwise, any office manager or senior secretary could be regarded as part of the senior management team. Now, to extend that further, if, for example, the director of the shipowning company was not a lawyer, and all the NGM did was to farm it out to an external law firm to do the same activities, there would be no way you would consider those external lawyers acting as senior management. So those activities really can't tell you very much about, sorry, they can tell you a great deal. They can tell you that they're not members of senior management, but they do not in any way support the notion that they are. Now, the mere fact that NGM and FML are carrying out management functions, whether commercial or technical, doesn't change that. The reason they're carrying out these functions is because they entered into a management agreement with Delos to arrange that, to deal with those matters, essentially as an outsourcing mechanism. Now, the management agreement for FML is in the supplementary bundle. I don't need to take you to it. And there was a similar management agreement in relation to NGM. But just because a ship-owning company, whose purpose, I would say, is to exploit, for commercial purposes, an income-producing asset, chooses to have the commercial and technical matters managed by another organization, doesn't mean that somehow or other Delos is divorced from those matters. It's just chosen to outsource them for the time being. So we would say on these basis of the findings of the judge, which are extensive and complete and emphasize the limited role Mr. Bayraktaris had, the judge was absolutely right to hold that he was not a member of the senior management, and therefore his knowledge could not be attributed to Delos. Now, the insurers have made a number of arguments. The first is, I've already explored, that the judge failed to properly consider what the activities of Delos were, but the judge did consider what the activities were. It went beyond legal and financial formalities. But even on that basis, even in legal and financial aspects, the judge did consider whether that, even if the activities were so limited, even in those circumstances, Mr. Bayraktaris was not a member of the senior management. Again, the judge apparently misconstrued, according to the insurers, the word organized. We say that she did not. The key notion here is whether Mr. Bayraktaris has a significant role in deciding how the activities of the company were managed or organized. Not whether he participated in the organization, whether by making things happen in accordance with someone else's decision. It's the actual decision-making authority which is critical to the definition of senior management. And the insurers also say, my learned friend says, that the judge was wrong to have regard to Mr. Bayraktar's role as an external lawyer as a nominee director. That was his evidence. She assessed the evidence and she came to the particular conclusion she did. There was no reason to dislodge or find that the judge misunderstood the evidence. Now, looking at the, I think my learned friend says in her skeleton argument, paragraph 17 is page 75 of tab 4. There is no basis, sorry, I beg your pardon, this is the fifth last line in paragraph 17. You can see on the right-hand side, there is no basis for the claimant's assertion in their skeleton that directors who do not perform a high-level managerial or organisation role are not included in senior management. The test is whether you play a significant role in the making of decisions. Well, we would say there is every reason to have that assertion because that's what the Law Commission said in paragraph 8.58, to which I've already taken you to. And again, the whole pulse of the Act is to identify key or high-level individuals within an organisation as counting as senior management, to whom the knowledge of the company, to whose knowledge can be attributed to the company for the purpose of the duty of fair presentation. And then in paragraph 18, they go on to say, the insurers go on to say, the judge's reasoning leads to the startling conclusion that Delos, in fact, had no senior management at all. It is most improbable that this was what Parliament and Law Commission intended. Well, the judge certainly did say there was no requirement that a company has senior management. This is what she says at paragraph 206 of her judgment. But and there's nothing which says you must have senior management from within. But there's no reason why senior management can't come from personnel from without. So you, for example, there could be shareholders of the company, or there could be ultimate shareholders, or there could be beneficial owners. There could be other companies who make all the relevant decisions, particularly with this as an SPV, whose purpose is to own this vessel for all sorts of other purposes, other reasons. But still,
following up your submission about the indemnity agreement,
yes,
doesn't that at least tell us that some of the family members were senior management?
Yeah, our case was, and I think my learned friend's case was, at trial, that the senior management of Delos came from the Mendreas family, or NGM. But the allegation here is concerned with the knowledge of actual knowledge of criminal charges, and that was only known to Mr. Bayraktaris, to no one else. So, for the reasons given by the judge, based on the evidence as assessed by the judge, which was barely challenged in many respects, the focus of the challenge was really on the formalities and the paperwork which Mr. Bayraktaris carried out. On the evidence as given, as assessed by the judge, there is no scope for contending, we say, that Mr. Bayraktaris was a member of the senior management of Delos. And of course, before this court, there's no allegation that it extends to NGM in any case. So that brings me on to constructive knowledge, unless there are any questions from my lady and my lord to senior management. Then constructive knowledge. Now, the insurers argue that Delos and NGM, and there's obviously an issue about FML, which we'll come back to when we deal with composite policies, should be fixed with constructive knowledge because a question should have been put to Mr. Bayraktaris by senior management or by Mr. Souris, who is the insurance manager of the NGM, whether he was aware of any information, as Mr. Bayraktaris was aware of any information which could affect the risk to be insured. Now, they present this argument, as I say, even though Mr. Bayraktaris had no knowledge of the insurance requirements. He had no operational role in the management or operation of the vessel. He'd never been asked this before. And there's no evidence that this was a question asked in the shipping community. The judge made that clear. There was no evidence that this was a question normally asked by those in the shipping community. Now, you've seen, I'm not going to take you to the provisions of the Act unless you wish to see them again, but they're quite straightforward. There is obviously the should, would choice of language we'll come back to. But I think that's well in mind, I hope, and I don't need to draw your attention to it. The judge said, paragraph 210 of her judgment, you can see it, page 210 of the bundle. So she begins at paragraph 209 by quoting section 406, identifying what an insured ought to know means. What should reasonably have been revealed by a reasonable search of information. So having said I won't take you to it, I've just shown you it. And then paragraph 210, she says, I accept that the express obligation in the Act to make reasonable searches represents an extension to the previous law, which referred only to matters which ought to be known to the assured in the ordinary course of business. There is, of course, some overlap, but the reference to reasonableness clearly imports an objective standard and is accepted by insurers that what is reasonable must depend on the context and type of business which the insured is conducting. In this case, a family-owned and run Greek shipping company. And she goes on to say, in my judgment, in agreement with the Law Commission report accompanying the draft bill, the test is correctly described as an objective test by reference to a reasonable, prudent, insured in that class. Now, the judge then refers to two categories of inquiry which should have been made. Fit and proper inquiry, which is not pursued on appeal. And then the insurance inquiry, which you can see referred to at the bottom, page 212. Now, I think in paragraph 24 of the insurer's skeleton, which is tab 4, page 68. The insurers put forward a number of errors made by the judge in her decision. And at paragraph 24, they say these errors are not based on findings of fact. Instead, the errors which were made concern how the judge should have approached the relevant questions. Now, pausing there, I do say they're made on an assessment of the evidence, applying an objective standard, which is required under section 4.6. Indeed, it is striking that in the 4 short paragraphs of the judgment dealing with the inquiry and response, there's not a single reference to objectivity or reasonableness. Now, it's true to say when the judge deals with what's described as the insurance inquiry, she doesn't expressly refer to objective or reasonableness, but she has done that in the preamble to this part of the judgment. So to suggest that she was not applying an objective or reasonable approach to these questions is, I think, an unfair submission. Now, the way the judge put it, and I think the way it's put now is whether Mr. Bayraktaris knew of any circumstance which might affect the risk. But actually, the way it was pleaded was, did Mr. Bayraktaris know of any circumstances which might influence the judgment of a prudent war risk insurer in assessing the risk? So the question should be put to him, do you know, Mr. Bayraktaris, of any circumstances which might influence the judgment of a prudent war risk insurer in assessing the risk? So that's the way it was pleaded. And just when you see that expanded form, it becomes more and more difficult to see why the question would be put to Mark Bayraktaris reasonably, and why you would expect Mr. Bayraktaris to answer it by disclosing the criminal charges. I'm going to come back to this in a moment, but it is important to bear in mind when addressing this question. Firstly, was it reasonable or not reasonable for the insurers, from NGM or Mr. Souris, not to ask this question, or was it reasonable for them to ask this question of Mr. Bayraktaris? So it's not necessarily the question which matters, it's the person to whom the question should be addressed. And secondly, what response would have been recovered by virtue of that request, or by that reference to that inquiry? This is where the should-would point comes into play. Now, if we go back to the judgment, paragraph 216, page 213 of bundle of tab 8. Having looked at the insurance inquiry referred to in paragraph 215, the judge says, again, I find this implausible. So the reference to again is the judge's dismissal of the fit and proper inquiry, which is referred to in the previous section. Given that Mr. Bayraktaris had no operational role or function regarding the trading of the vessel or her insurance, he would not have known anything about the risk to be insured, and asking him would have been a somewhat pointless exercise. Mr. Suris' evidence was he did not even know who all the nominee directors were, although he accepted he could have found out. I very much doubt he asked questions of any nominee directors in Panama. And then I'll come back to 217 when I deal with the response. But just as far as the reasonableness, if you like, of not asking Mr. Bayraktaris whether there were any circumstances which might influence the judgment of a prudent war risk insurer in assessing the risk, the judge was clearly right and saying this was an implausible prospect because, firstly, Mr. Bayraktaris had no operational role in the management of the ship, had no role or knew anything about the risks to be insured, had no role in relation to the insurance requirements of the vessel generally. And when the judge refers to, again, she had earlier said, in relation to the other inquiry, the judge that one can't draw analogies between public companies, the way they operate, and how these ship-owning groups operate as well.
Is the question whether the judge was right, or is the question whether the finding that it was reasonable not to ask was open to her?
When you say open to her, I'm not sure I understand.
Well, whether it was a finding that she was allowed to make on the evidence.
I didn't see why she couldn't have made that finding. That's what both parties addressed her on, and she made a finding accordingly. Maybe I'd misunderstand my lords.
Well, the question is, what is the test on appeal? Is it a question for us, right or wrong, or is it a question whether the judge got it wrong?
Well,
in a way that she was not entitled to come to.
Well, as I say, this is an assessment of the evidence. So we say that the appeal should only be allowed if the court was of the view that she was plainly wrong in her assessment, applying the test. There's no real indication that there's an issue of principle involved in terms of the formulation of the question to a particular person, or the making of a question, or the making of a question to a particular person. That's not. She considered that and she dismissed it based on the evidence, applying a reasonable and objective standard.
So you're saying it's a mixed question of fact and law, and she came to a conclusion which was evaluative on the basis of the evidence, and she was entitled to do that.
She was. I would actually go so far as to say it's purely a question of fact, because, yeah, but, yeah, so I don't even know what the issue of principle is when it comes to whether or not it was reasonable or not reasonable for the ship owner to ask or not ask questions of Mr. Bayraktaris in relation to this particular point.
Well, there's perhaps one issue of principle identified, which is if it was material, then it must have been reasonable to make the inquiry.
Well,
to elicit that which is material.
The problem with that approach, my lord, and why I say it's wrong, is that as the judge said in paragraphs 209 to 11 of her judgment, when dealing with what's objective and reasonable, one looks at it from the perspective of a reasonable insured. When one considers the position of materiality, one considers it from the perspective of a prudent insurer. And that's a discrepancy you just can't get over. So if the argument is, if it's material, it follows it would have been reasonable to ask Mr. Bayraktaris. That's wrong because of the discrepancy. But also, it doesn't tell you, it may tell you what questions you should ask, but it doesn't tell you anything about who you should ask. Because you won't know. I mean, you don't know anything about the criminal charges of anyone. If anything, you expect anyone who is charged with a criminal offence to tell you as your principal that they have a criminal charge brought against them. But that wouldn't happen. This didn't happen in this particular case. So if that's the point of principle, it's not a good one. And the objection she didn't approach it objectively is just wrong, because she had clearly had in mind the objective nature of the provisions of the Act. So then we come to the question of the response, and she dealt with that at paragraph 217 of her. So this is assuming it would have been reasonable for and to be expected for the insured to ask questions of Mr. Bayraktaris. And remember, the question is, do you know of any circumstances which might influence the judgment of a prudent war risk insurer in assessing the risk? Now, there are a number of points to be made here. The first point is just dealing with the could-would position. Is it should-would? I beg your pardon. Should-would, not could-would. The mere fact that the word should is included is, we say, doesn't tell you anything, because the whole nature of these provisions, the whole nature of the duty of fair presentation, is to impose a duty of reasonable search upon the insured. It is not to impose any duty of reasonable answer upon the recipient of the inquiry, who is not an insured. So it would be unfair for an insured to be saddled with information which, looking at it from the perspective of the recipient of the inquiry, should reasonably have been provided in answer to the question, if they choose not to. But I would go further. This is clearly something which was not in the mind of the Law Commission. And I say that because if you look at going to Authorities Bundle tab 4, Authorities Bundle 4, tab 47, page 1437. Sorry, 1437. You'll see under the heading, matters which should reasonably have been revealed. We recommend that the insured ought to know only what should reasonably have been revealed by the reasonable search. The insured should not be taken to have constructive knowledge of information which could not reasonably have been discovered, such as information which would have been withheld through negligence or fraud. So just pausing there, if the recipient of the inquiry negligently failed to respond to an inquiry with relevant information, the insured should not be saddled with that knowledge. And the Law Commission go on. We think this reflects the current law. Australia and New Zealand Bank against colonial and legal wars confirmed that the results of any search could not be expected to include an admission by a servant of his own negligence. In contrast, the knowledge of an agent to know who could be expected to keep their employer or principal informed of relevant information may well be included as what the insured ought to know. So now you'll see, I'll come on to this now. So if you go back then to the explanatory notes, at tab 46, page 1405. Paragraph 56, which refers, you can see from the previous page, to section 4.6. And at the top of page 1405, after at the top of the first line, it says it largely codifies principles derived from some case law, namely that insureds should seek out information about their business by undertaking a reasonable search. And then in paragraph 57, future interpretations, section 4.6 and 4.7, is likely to be guided by existing case law. For example, a search may not be expected to evince an admission by a servant of their own negligence. And the footnote refers to the Australian New Zealand Bank case, which the Law Commission referred to, at footnote 15. In contrast, the notion of an agent to know who has a duty to communicate the relevant information to their employer may well be included. And that's a reference to Proudfoot and Montefiore. Now, an agent to know, it's not in the bundles, I'm afraid, but it traditionally regards three types of agent. The broker, the agent in charge of the relevant assets, such as a master of a ship, and thirdly, a general agent, someone who's has a general power of attorney to act on behalf of the insured. It would not cover someone in the position of Mr. Bayraktaris. Now, in assessing Mr. Bayraktaris' evidence, yesterday my learned friend said when dealing with the inquiry and how he would respond, well, let me just, before I do, let's go back to the judgment. You can see how the judge dealt with it, and then I can come back to my learned friend's submission. Paragraph 217, at page 213 of core bundle tab 8. It is, paragraph 217, it's true that Mr. Bayraktaris said if he had been approached out of the blue with a question as to whether there was anything that the insurers ought to be told, he might have deduced that it was a reference to the criminal charges and disclosed them on that basis. However, in an insurer's case, this would not have been an approach out of the blue. On the contrary, it would have been a question that he would have been asked regularly since his appointment on 16th of August 2007. It's therefore plausible that he would not have associated with routine question with the charges or mentioned them, given his evidence that he did not think them relevant to the performance of his functions.
I think I was mistaken yesterday in saying that he would only have been asked it once because the ship was only acquired in 2017 because, of course, he was the director of lots of companies.
He was the director of Delos since 2007.
Delos didn't have a ship, but he was the director of lots of other companies who did, and therefore, on this hypothesis, would have been asked this question for it anyway.
I think there were 6 other vessels he was a director of. Yeah.
So that's fair. Accept that.
That's very kind.
I accept that.
Thank you very much.
I had no intention to mislead, my lord.
No, of
but I
course not.
accept
No,
that.
I was just being too generous to you, as usual.
A little generosity this way would be very nice. Now, my learned friend did say that the evidence he gave in this respect was reluctantly given, I think she said, at one point. And it is worth bearing in mind what the judge said about Mr. Bayraktaris as a witness at paragraph 41, page 146. At the bottom of the page. Mr. Bayraktaris was a clear and precise witness. Given that his position was by no means a comfortable one, I find he answered questions frankly and honestly, and even if he was slightly mystified by some of the hypothetical scenarios put to him, I accept his evidence. So the reason he would be mystified, because he had no knowledge of insurance requirements, he wouldn't know what would impact the decision of a prudent war risks insurer in assessing the risk. And the only reason he said he may have answered this question out of the blue is he may have reasoned his way out of it. And the transcript's in the bundle if you wish to see it. But the judge has come to the conclusion that in the last sentence of paragraph 217 at page 213 of the bundle, it's therefore plausible that he would not have associated this routine question with the charges or mentioned them given his evidence that he did not think them relevant to the performance of his functions. And that, therefore, is again an assessment by the judge on the evidence. So unless the court were satisfied, subject to the should-would point, which I've addressed you on, is if the judge, unless the Court of Appeal thinks that the judge has got it plainly wrong, there is no real grounds for disturbing that finding. So, pausing there, my lady, my lords, we say that the appeal in relation to actual knowledge or constructive knowledge or senior management or ought to know, however we should put it, should be dismissed for the reasons given by the judge. And there is no principal basis on which to disturb the judge's findings, and there's no reason why the court should conclude that the judge's assessment of the evidence was plainly wrong. So that brings me to inducement. And I propose to deal with both the appeal and the respondent's notice. And the respondent's notice point is a pretty brief one. So, my lady, just to assure you, I'm making reasonable time. Now, inducement, of course, is now legislated in Section 8 of the Insurance Act, whereas it was not a feature of the Marine Insurance Act. It had to be read in by the House of Lords in Pan Atlantic. But now it's an express feature. And it's relevant for two reasons. The first is, without inducement, there's no qualifying breach of fair presentation, duty of fair presentation, which means there's no remedy available to the insurer. So at the very least, the insurer has to prove that it would not have come to the same decision had there been full and accurate disclosure. Which means either the insurers would not have entered into the contract at all, or would have done so on different terms. However, inducement has now an added significance under the 2015 Act, because depending upon whether the breach was deliberate or reckless, of which there is no allegation in this case, or the extent of the inducement will dictate the remedy available to the insurer in the case of a qualifying breach of duty. And you can see, it is worth having a look at, because I don't think you've seen it yet, at least not on this occasion. If you go to Authorities Bundle 4, tab 45, page 1392. Sorry, I beg your pardon. I should take you to 1381 just so you can see, just make good what I just said, under Section 8. The paragraph 1, the insurer has a remedy against the insured for a breach of duty of fair presentation only if the insurer shows that but for the breach, the insurer would not have entered the contract at all, or would have done so on different terms. 2, the remedies are set out in Schedule 1. And 3, a breach for which the insurer has a remedy against the insured is referred to in this Act as a qualifying breach. And then 4 and 5 are concerned with the definition of deliberate and reckless. So if we go back to 1392, you'll see in paragraph 1 that this part of the schedule applies to qualifying breaches of the duty of fair presentation in relation to non-consumer insurance contracts. And it says in relation to variations to the contract, you look at part 2. Then we can ignore paragraph 2, which is concerned with deliberate or reckless breaches. Paragraph 3, paragraphs 4 to 6 apply if a qualifying breach was neither deliberate nor reckless. Paragraph 4, if in the absence of the qualifying breach, the insurer would not have entered into the contract on any terms, the insurer may avoid the contract and refuse all claims, but must in that event return the premiums paid. And paragraph 5, if the insurer would have entered into the contract but on different terms, other than terms relating to the premium, the contract is to be treated as if it had been entered into on those different terms, if the insurer so requires. So the interesting thing about these remedies, no matter, even though they're more than avoidance, is that they require an election. They require the insurers to make a decision that they wish to exercise these remedies. Now, in this particular case, the insurer's case was, had the criminal charges been disclosed, they would not have entered into the policy at all or insured this vessel. Now, the judge found that what the insurers would have done is imposed a condition. So they would have entered into the contract subject to a condition that required the resignation of Mr. Bairataris. That was not the insurer's case at trial. Their pleading case was, had the criminal charges been disclosed, they would not have entered into the policy at all or insured the vessel. Never exercised a remedy about the condition. And we would say in those circumstances, their case was not proved. And therefore, even if the judge came to the conclusion that the insurers would have imposed a condition, that is not sufficient to demonstrate they would not have entered into the contract at all, would not have insured this vessel. Full stop.
So you're saying, are you, that the insurer never so required, and therefore this is all irrelevant?
Correct. Now, the judge, in a lengthy part of the judgment, the paragraphs 244 to 258, you'll see that at tab 8, page 223. And as I say, it's paragraphs 244 to 258, and I don't propose to go through all of that. But it is worth just picking out the following aspects of her findings. I mean, she bore in mind that this was evidence based on a hypothetical, something which didn't actually happen. She assessed the insurer's evidence, underwriter's evidence that is, as illogical and incoherent. She said it twice in her judgment. She also held, and I'll come back to this, that it was appropriate to take account of exculpatory material. She also held, and this is paragraph 248, as I've already held, the charges against, and what I think why she says already held, that's in the context of materiality. So she says the charges against Mr. Bayraktaris had no objective relevance to the risk of loss or liability under the policy, save possibly in relation to the potential prolongation of a detention which had been effected for other reasons. And I'll come back to that. But subject to that possible exception, there was no objective connection, no objective relevance between the charges on the one hand and the risks under the policy. And that was for obvious reasons, because Mr. Bayraktaris had no role in questions of operational management of the ship. She also says the criminal charges did not reflect on the credibility and reliability of NGM. And she says that in paragraph 250. Sorry, I beg 240. I've got this wrong. 249. I'm so sorry. And then the remainder of her judgment in this respect really is concerned with an assessment of the evidence given by the two underwriters, whose evidence was called by the insurers. Now, there is the grounds of appeal is the first ground of appeal, which is relied upon by the insurers. It concerns exculpatory matters. So this is the notion that there should have been there was a non-disclosure of the fact that Mr. Bayraktaris, as the director of Delos, had been charged with a serious criminal offence. And the exculpatory matters really are the matters which identify the fact that, well, he was a nominee director, he was acting under the instructions of NGM, has no operational role whatsoever in relation to the ship, no involvement in the insurance, etc., etc. They're the exculpatory matters.
I think they also included the fact that he denied the charges, etc.
He did, that's true. Now, the first point I think my learned friends take is that the judge was wrong to include these matters on the grounds of procedural unfairness, because adequate notice of these points was not given to the insurers, and reference was made to Lord Justice Christopher Clark's judgment in AXA and Arab Insurance. That such notice should be given either in the pleadings or by way of witness statement. That, with my submission, is an unfair submission by my learned friends. There was adequate notice, and I'll explain why. The first is, if one looks at the pleadings, and that you can see this in my client's reply, tab 14. Paragraph 20C, page 299. There's a plea by, firstly, by that Mr. Barataris is not guilty of the criminal conduct. But as my learned friend, Ms. Hopkins, said yesterday very fairly, that there was never part of their case that he was, just merely that the charges were made. And you can see at the top of the next page, paragraph 3, that Mr. Barataris strongly denies the charges and at all material times maintained and continues to maintain that they are unfounded. So that addresses, my lady, your point just a moment ago. Then in paragraph 20E, there's a response to 26B of the defence, which is concerned with materiality. Without prejudice to the foregoing denial, the claimant's plea further as follows. So we denied materiality. It's denied that the matters termed by the defence as the third material circumstances, which are these criminal charges, were material within the meaning of the Act. The claimants refer to and repeat paragraph 20C above, which I've just taken my lady and your lordships to. Paragraph 2, without prejudice to the generality of the foregoing, the claimant's plea further as follows, and it goes on to the next page. Mr. Barataris assumed the role of nominee director, the first claimant, in 2007. As a nominee director of the first claimant, Mr. Barataris' role was at all material times restricted to corporate administrative matters. He did not at any material time play any significant role in the making of decisions about how the first and second claimant's activities were to be managed or organised. He was not involved at any material time in the day-to-day running or operations of the claimants and with the operations or management of the vessel, and was not responsible on behalf of the first and second claimants for placing or procuring any insurance policies for and in relation to the ship. And it goes on also in subparagraph 3 on the next page. And then, if you go to page 305, where paragraph 36F is denied, this is denying inducement. Without prejudice to the foregoing denial, with regard to the alleged role and authority of Mr. Lavignol, we can put that to one side. It's denied that the claimants were in breach of the duty to make a fair presentation, referred to and repeat paragraph 20E above, which is denied the claimants were in breach to make a fair presentation, whether as alleged or at all. It's denied the defence were induced to conclude the policy on the terms they did by reason of third material non-disclosures. Paragraph 20E2 above is repeated, so they're the points, what I would call the exculpatory matters. And it's denied that the defendants would have refused to write the risk at all, or would have refused to insure the vessel on the policy on the terms agreed. Again, references back to paragraph 20E. Now, the facts referred to in this plea are set out at length in Mr. Mandreas' evidence, Mr. Barataris' evidence, Mr. Souris' evidence. And just to make it absolutely clear that the underwriters knew exactly what the case was being advanced against them, which was addressed during cross-examination. One need only look at the two underwriters' witness statements, second witness statements, in the supplementary bundle, tab 21, page 102.
Sorry, tab 21, page
102. I hope that's right.
Yes, it is. Thank you.
This is Mr. Dinefler's witness statement, one of the two underwriters. At paragraph 2 on the next page, I've read section B, Mr. Barataris' first witness statement, where Mr. Barataris goes through his role as a director of Delos and confirmed that it does not change how I would have assessed the risk. In assessing the risk, I would be interested in the management as a whole, including the legal director. Even if the legal director only had the duties described by Mr. Barataris in section B of his witness statement, I would still not have agreed to renewing the policy. And the same point is made by Mr. de Lavignol in the next tab at page 107, paragraph 2. And paragraph 3, I should say. So the suggestion that there was not advance or adequate notice of this argument based on exculpatory matters is just wrong. But what about the question of law associated with this? Is it permissible in addressing and assessing whether or not there's been a breach of the duty of fair presentation? The question to be asked is should the presentation be limited to the non-disclosure of the information pleaded and relied upon by the insurer without regard to any additional information? Or should relevant information which would have accompanied that disclosure also be taken into account? Now, there's an obvious disadvantage if the former were opted for by this court, because it would leave the insurers with massive tactical advantages how they plead their non-disclosure, which can't be right. And anyway, this point has been addressed on now 3 occasions. Firstly, by the Court of Appeal in Drake and Provident, which my known friend Mr. Walsh took you to yesterday. Secondly, by Mr. Justice Blair in a case called Sea Glory in Alsagra, which is not in the bundle, I don't think. But it is referred to by Mrs. Justice Dias in her judgment of paragraph 228. Which is at page 217. I called it Sea Glory against Alsagra. It's actually called the Nancy there. That's a ship's name. You can see that in the top of page 217, where Mr. Justice Blair followed the approach of the majority in Drake and Provident. Now, as far as the exculpatory, I mean, Drake and Provident was an interesting case because that was a case where when the driver took out the insurance, he informed the insurers that his wife had had an accident which was her fault, but he did not disclose his speeding conviction. In truth, so they relied upon the non-disclosure of the speeding conviction, the insurers, that is. But the Court of Appeal had to consider, well, was it also permissible to take into account the fact that the accident he referred to was actually not the fault of his wife, so it made the risk sound worse than it was. And the Court of Appeal said you have to have a regard to the real facts, not just as presented, but the facts as they exist. Now, in the Nancy, and that was by majority, Lord Justice Pill came to a dissenting opinion. In the Nancy, Mr. Justice Blair was faced with a similar question. The non-disclosure alleged was that the vessel had been detained twice by, this is a claim under hull insurance, but it had been detained twice by port state control because of things which went wrong with the vessel. Now, these are not holes in the side of the ship or anything. These are like fire extinguishers not being in the right place, etc. And what happens is with port state control, they say these are the problems, and you're not allowed to go until you fix it. And in each of those occasions, the owners fixed them, and they were allowed to go within a couple of days. And the court had to consider, well, when considering the materiality and inducement issues arising out of the non-disclosure of the detentions by port state control, was it legitimate also to consider the fact that the owners had rectified the problems immediately identified by port state control? And the judge said yes, applying Drake and Provident. And of course, the third authority, of course, is the decision of Mr. Justice Dias in this particular case.
Well, the AXA case is.
That's true. That's true. Isn't
that called real? I mean, if you have to be procedurally fair about it, that rather suggests that it is a relevant consideration.
And he does say that. My Lord Justice Clark, Mr. Christopher Clark does say that, yes.
I think Mr. Walsh was more or less inclined to accept that, but he says the 2015 Act makes all the difference.
That's what I'm going to come on to now, if I may. So, of course, one bears in mind how the definition of materiality, because this is relevant not only to inducement, it's also relevant to materiality, we say. Because to address materiality of criminal charges, you need to take into account exculpatory matters. And in order to address inducement, you need to take account of both matters as well. Now, the test of materiality is no different under the Insurance Act. It's exactly the same as it was. It's a prudent insurer test. The test of inducement, I would submit, is no different either. The difference is the remedies flowing from inducement alter. The test of inducement is the same. I'm pausing because I'm expecting a question, but
I had thought, and I may be entirely wrong, that under the old law, the test is whether it would have affected the mind of the prudent underwriter.
materiality.
Yes.
No, I'm talking about inducement of the actual underwriter.
And it had to have made an actual difference as to the terms on which it was written under the old law.
And I think that's under the new law too. Now, we say the law has not been changed because the test of materiality and inducement hasn't altered under the new Act. Remedies have altered, but the test hasn't. And if one looks at the explanatory notes of paragraph 77, Authorities Bundle 4, tab 46. So just to make good the last point, paragraph 77.
77?
77, sorry,
Thank
I beg your pardon. The insurer must show that it would have acted differently if the insured had not failed to make a fair presentation. That is, that the insurer would not have entered into the contract of variation at all. It would only have done it so in different terms. This reflects the current law on inducement. Then, if one then goes to paragraph 1178 of the Law Commission report, which is at next tab, page 1453, now, paragraph 1177, there's a comment that the insurer may have been willing to contract on a number of bases. Right? And we can pass by that. And then 1178, we believe that the courts are best placed to decide what evidence is admissible and sufficient to show how the insurer would have acted. This is in the context of inducement. The courts make similar decisions at present when deciding issues of materiality and in particular inducement. And if one looks at footnote 27, see, for example, Drake against Provident, in which the Court of Appeal examined not only what the insurer would have done had a speeding conviction been disclosed, but also whether this would have led to discussion of an earlier accident, resulting in its reclassification in the insurer's records as being no fault. So clearly the Law Commission had in mind that this would still continue to play a role, this concept of exculpatory materials. I think my learned friend, Mr. Walsh, said yesterday that, well, there's obviously going to be an issue about, I think the phrase he used was bright line or something like that. I think that's right. So where do you draw a line? And of course, in the three cases I've referred to, not the AXA case, but the Drake, Sea Glory, or the Nancy, and this case, you don't need to, the information, the exculpatory material comes immediately and unquestionably in connection with the non-disclosed circumstance alleged. You don't need to got involved in the full exchange as to where you have to draw a line. Whether it's the port state control errors were all rectified, or whether it was the fact that the accident was fault or no fault. In this particular case, when you describe the role of Mr. Bayraktaris, that is easily said. It doesn't require a never-ending exchange. These are all matters where a bright line, if that's a requirement, can be drawn. Now, I think the next point which my learned friends take is that it was neither party's case was that a condition would have been imposed in the manner in which Mrs. Justice Dias alleged. Now, I think that's fair, but what's important is what the insurer's case is. Now, the insurer's case was they would not have entered into policy at all, or would not have insured their vessel. And our evidence demonstrated, particularly Mr. Mandreas' second statement, that had he been required to procure the resignation of Mr. Bayraktaris, he would have. And one of the avenues of questioning the underwriters as to their inducement evidence, which was they would not have entered into the contract at all or insured this vessel, was, well, as long as you were satisfied that Mr. Bayraktaris was removed, then you would have been happy to insure the vessel or enter into the contract. And that was done with a view to demonstrating that their case on the non-disclosure of this evidence, of these criminal charges, can't have been correct. They would have entered into the contract. They would have insured this vessel. And these matters were put, it may be suggested that these matters weren't put to the underwriters, that they were. Just for your note, it's tab 30 of the supplementary bundle, pages 185 and 196. Then the next point I think my learned friend makes is, well, it wasn't open for the court to find on the evidence that had a condition been imposed, the claimants would have complied with it.
No, it wasn't quite that it wasn't open on the evidence, it was that it's legally irrelevant.
Sorry, you are absolutely right. I'm sorry about that. So, firstly, the judge found it was, they would have complied with it on the evidence. The question is, could they, is that a relevant consideration as far as the judge is concerned? And I think reference was made, if we go back to the Authorities Bundle 4, the Law Commission report, tab 47, page 1454. Uh, 1182, top of the page. Similarly, it should not be open to an insurer to say it would have complied with any term which the insurer would have imposed, for example, an exclusion or a warranty, and so the loss should be covered. During consultation, the example was put to us of a business which keeps its vehicles in an area which has suffered a series of thefts of commercial vehicles. The business fails to disclose this and a vehicle is stolen. The insurer responds that had this information been properly disclosed, it would have required the vehicles to be parked in a more secure location, which the business says it would have done if this term had been imposed. Consultees were rightly concerned about the circularity of such arguments. Similar arguments apply to insurers. We do not think that the inquiry should extend to whether the insurer would have reinsured the risk or acted differently in accepting subsequent risks. This is necessary to prevent complicated evidential arguments arising about how the insurer would have conducted itself and the terms on which it could have been obtained reinsurance coverage. Now, the way it was addressed by the judge is at Core Bundle 8, tab 8, page 257. I think I got that wrong, sorry. I think it's 227. Thank you. Now, paragraph 256, having quoted from 11.82 of the Law Commission report, the judge says, I accept that we're going too far if an insured could simply say that it would comply with any term the insurer cared to impose, not least because in the example given, compliance with a warrant to keep the vehicle in a secure location. It would have been completely speculative whether the requirement would in fact have been observed on an unknowable occasion which necessarily lay in the future. In the present case, however, the replacement or resignation of Mr. Bayraktaris is something which insurers would have required as a precondition to cover. And on the evidence, I'm satisfied it would have been complied with. Now, what the judge was doing was drawing a distinction between terms which required the performance of the insurance contract, which was addressed by the Law Commission, such as a warranty that vehicles insured would be kept in a secure location, and terms which would be imposed prior to the attachment or the inception of the risk, because that's part and parcel of the process of agreeing the insurance contract.
Is she just making a point about the facts? She's saying that in the one case, the secure location example, well, you couldn't prove it, but in Mr. Bayraktaris' case, you could prove it, and that's a distinction which seems to be more to do with the strength of the evidence in any given case rather than with the question of legal principle.
That's true, but she also does make a distinction in this paragraph between warranties which have to be complied with during the performance of the contract, and as she says in the last sentence, it's something which insurers would have required as a precondition to cover. So this is to the actual attachment of a binding insurance contract. Now, of course, the fact it's concerned with a matter before attachment of an insurance contract, or an insurance contract becoming binding, is something which is readily proved by the evidence, or we say in this case it was. But when it's something to do with how the contract of insurance is performed, particularly if there's a warranty requiring during the entire period of the insurance that cars will be kept in a secure location, that's a much more speculative exercise.
But it wouldn't a condition as to Mr. Barrack-Tyrus not being a director apply throughout the course of the policy?
No, because it's a precondition to the attachment of cover.
Right. So let's say that he resigns on the day after what would otherwise be inception. Would there be cover?
No, because, well, the cover only attaches once he's resigned.
Yeah. So it's something that happens during the course of the policy. It depends upon whether there's cover or not. Equally, if he'd resigned before inception and then was reinstated on day 3, there'd be a breach of the condition.
Well, in that case, yes, I expect there may well be. But as
doesn't that illustrate that the condition is something which it reflects what's happening in terms of the course of the cover?
No, because I hadn't finished my answer. Because yes, there would have been a breach of condition, because one could look at the subsequent appointment on day 3 as being that the procuring of the resignation beforehand was not a sincere attempt at complying with that condition, as a matter of evidence. So if it was a warranty that at no stage during the performance, the period of the cover, that Mr. Barrack-Tyrus shall be a director of the, that's a performative duty. If, however, it's concerned with the very existence, coming into being of a binding contract of insurance prior to attachment, that's something altogether different. Therefore, we say the judge's approach makes sense, and there's no reason why one can't have regard to that evidence. But the bottom line is, and this is where our respondent's notice comes in, and I should make it clear, we do make a point in the respondent's notice about whether the judge applied the right test of cause inducement. I don't pursue that before this court. This is the effective or non-effective cause of the breach, or whatever it is. I forget what it is. But what we do say is, on her findings, on her evidence, on the evidence as she assessed it, she should have found that the insurer's case, that the insurers would not have entered into the policy at all or insured the vessel had there been full disclosure of the criminal charges, cannot be maintained. And we say that's absolutely clear, having regard to her assessment of the underwriter's evidence as illogical and incoherent. And so no, I think that dispatches the appeal.
Is that on the basis that... no, sorry. No, I won't ask that.
We should. I mean, if you...
No.
Okay.
No,
I'm not going to force you.
My misunderstanding.
Okay. Well, I hope my submissions are clear. And unless my lady or my lords have any further questions on inducement, I'm going to proceed with materiality. I know, I mean, of course, you can ask me further questions after the break if you wish to about inducement, or anything for that matter. Not that you need my leave.
I think that it's probably the appropriate time now, especially as we started at 10, to break now before you begin another subject. Thank you very much indeed. 2 o'clock.
What, Ryan, is any more?